If I initiate litigation, is there a way to stop it? Are there any choices or control that the other side may have in determining whether I can do that? Does the judge get involved? Those are some of the questions we're going to talk about today. I'm Michael Miller. I'm a partner at Cole Miller PLLC. We're a family law firm located in Vienna, Virginia, serving primarily in the Northern Virginia area. I analyze challenges and find affordable solutions for families and their family law needs. So what we're essentially talking about today is what's called a non-suit. And Virginia Code Section 8.01-380 is the statute that provides for that. Now, in the context of broad civil litigation, this has lots more wide-ranging effects and implications than it does in the typical family law scenario. So let's talk about what a non-suit is. A non-suit is a voluntary withdrawal or dismissal of a lawsuit by the party that filed it, and that it allows the party to later bring a second suit on the same cause of action. And Virginia is unique in this regard in that they do have this non-suit and the provisions that's in that statute there. One of those provisions is a non-suit. The first time is by matter of right, meaning nobody can stop you. You get to do it. You don't need approval or anything like that. So if you initiate your litigation and for some reason you want to stop, you can take your first non-suit as kind of a free non-suit and stop the case. Then if you refile the case, you could take a second non-suit, but the second and subsequent non-suits have to be by leave of court. You have to have the judge's permission to do that. What the courts don't want you to do is to keep initiating litigation and stopping litigation and reinitiating litigation and stopping litigation. One of the things here is if the court does grant a non-suit on a second or subsequent filing, then the court can assess the cost and reasonable attorney's fees against the non-suiting party. There can also be fees if you non-suit within 7 days of trial to cover, witness fees and travel and things like that. So, as I said, use more on the civil litigation side for personal injury and things like that, where they're trying to beat statutes of limitations and worried about trying to get experts in and trying to see how the case is going to go. Less frequently used on the family law side. The one place we see it most frequently used is one spouse may initiate their case in the Juvenile Domestic Relations District Court. There's a provision in the law that says if the other spouse files a case in the circuit court and dockets certain matters to be heard within 21 days, then they divest the JDR court. And so kind of the gamesmanship you see is one spouse will file a case in the JDR court to determine custody, visitation, and support. The other spouse will come back, file in circuit court, file the divorce, put a motion on the docket to divest the JDR court, and then once the JDR court's shut down, then they non-suit in the circuit court and the whole case comes to a screeching halt. You have to go back and basically restart everything over again from scratch. So the one way to prevent that and kind of the one limitation on the non-suit is that a party shall not be allowed to non-suit a cause of action without the consent of the adverse party if the adverse party has filed a counterclaim, cross-claim, or third-party claim that arises out of the same transaction. So this is where if the other party does go through and file that suit for divorce in the circuit court to divest the JDR court, then you can come back and in response to their complaint, file a counterclaim or make some sort of claim that would preclude the other side from non-suiting. They can withdraw their complaint, but now your matter would still be able to go forward. So at least you get to stay into court and address the concerns you may have initiated in the JDR court, such as custody, visitation, and support, and so forth. One of the other matters here on the non-suit is that in civil litigation you may have multiple defendants. So you could say have a doctor and a hospital, both named as defendants in a case. In the course of the conduct of the case, the plaintiff may settle with the doctor, but still want to preserve cases or preserve claims rather against the hospital. So what you would do is you would non-suit with regard to the doctor, but you would keep your case going with the hospital. If you later settle with the hospital, now all defendants have settlement, and so it would, the entire case would be dismissed because of you would non-suit each of the potential defendants. In a divorce case, you don't have multiple defendants; you just have the other spouse. So, if you essentially if you non-suit against the one defendant, it basically brings the case to the end. So that's something to keep in mind. If you do initiate a divorce litigation and decide to reconcile, or you want to, stop pursuing the divorce, or you're able to work out your differences by agreement and want to stop the litigation, it's available to you to do that through the process of the non-suit under Virginia Code 8.01380.